Okay, good morning. Let's call the Legislative Committee on Administrative Rules to order. First item on the agenda will be approving minutes of January 13th and February 10th. And would you be so kind, Representative Higley, to introduce yourself? And we will go clockwise.
Sure, Representative Mark Higley, and I represent the towns of Lowell, Jay, Westfield, Troy, and Eden.
Representative Trevor Squirrel representing Jericho and Underhill.
Senator Mark McDonald representing most of Orange County.
Anthony Dexter Cooper from the Office of Legislative Counsel.
Representative Seth Blumgartz, Bennington 4.
State Senator Joe Benning, represent the Caledonia District, including the remainder of Orange County.
Charlene Dindo is in our command center behind us, flipping the switches and turning on and off the electronics. And we are ready to go with the first item would be to approve the minutes of January 13th, 2022.
So moved.
It's been moved that the minutes from January 13th be approved. Is there any discussion? If there is none, all those in favor, please say aye.
Aye.
Opposed, say nay, and the minutes 13th have been approved. And February 10th. Minutes for February 10th. Is there a motion?
So moved.
Been moved that the minutes be approved. Is there any discussion? Minutes of February 10th. If not, all in favor say aye.
Aye.
Opposed say nay, and the minutes have been approved. First item on the agenda, the Department of Health and Emergency Administrative Rules for remote hearings for the Board of Medical Practice. We've got a couple witnesses on call for this one, but I would ask that our attorney share with us a thumbnail sketch of where we are vis-a-vis
It's just David Engler there who wants to talk about it.
so this is okay. These are ones that we have already
You
heard
already
from.
took testimony on this at your last meeting, and you did not have quorum on this one. And I think it's just David who's here to testify again.
So
Let's hear from him.
David Englander is here from Department of Health, and for those listening, this committee didn't have a quorum at the last meeting and took extensive testimony and asked a variety of questions. Some members of this committee were not present, but they were on Zoom and also participated. So we didn't have a quorum in the room and we were not able to act. Perhaps Mr. Englander, you would start us off if you have anything new to add or a review of what is before us would be welcome. Thank you.
Of course. Good morning. My name is David Englander. I'm the Senior Policy Advisor to the Commissioner of Health. What you have before you is the remote hearing rule for the Board of Medical Practice. As the chair mentioned, we discussed this at length about, I think it was 2 weeks ago, although it seems like longer. This is the second renewal of this rule. This allows the Board of Medical Practice to conduct hearings under its purview in a remote setting. And these rules were actually based on OPR's rules. The purpose of this renewal is to allow continuity for rules to continue, for hearings to continue to take place in a remote setting. It also saves, most of the board members are medical providers, and during the course of the pandemic, they are still largely devoted to the response. This saves a tremendous amount of time in terms of travel to and from hearing sites. The final rule has actually been filed with this body, and so we don't anticipate a further renewal of this rule. And with that, I'd happily take your questions.
Once again, for those listening in, we have already heard on this one, and we're reviewing it today because we have the people present to vote. So if we appear to be moving rapidly, it's not because we have not considered it, but because we have already taken extensive testimony. So if there are no questions for the witness,
Move it.
Representative Bogard Baumgart's has moved that we approve the rule. Is there any discussion? If not, all those in favor say aye.
Aye.
Those opposed say nay, and the rule has been approved. Next item on the agenda, 21P38, Cannabis Control Board, licensing of cannabis establishments. This is the first in a 5-part series of rules having to do with cannabis. The first 2 parts of this 5-part series, we took testimony on and asked questions of witnesses 2 weeks ago and did not vote on it because we did not have a quorum. And representing the Attorney General's office is Assistant Attorney General David Scher. Is he present here today?
Yes, Mr. Chair.
Oh.
And to clarify, I'm actually no longer an Assistant Attorney General.
I mistook it for you not being here. The floor is yours, sir.
Thank you, Mr. Chair. And just to clarify, I'm actually no longer an Assistant Attorney General. I am the General Counsel of the Cannabis Control Board and technically not working for the AGO anymore. But thank you, Mr. Chair. And as you noted already, the committee already did hear some testimony on this, heard my presentation on this, so I don't want to belabor anything. There's only one brief point I'd like to add, which I didn't really talk about last time. And that was just that although the rules you see in front of you are the product of an enormous amount of work and public input on the board's part, they really are just the next step in they are building off of a framework that was itself an enormous amount of deliberation, consideration, and public input. And that framework, of course, is the legislation that enabled the board. And we were very careful to stay within the intent and the letter of that legislation in doing so. And so this really is not just a board effort, but really the next step in what has been a multi-year, carefully considered process.
Are there any questions for the witness? What's the committee's pleasure?
We'll take them one at a time. Right. Rule 1.
Yeah, we're gonna
Okay.
we will we'll take them one at a time.
Okay. 21P38, I move that we approve the rule with the modification proposed by the Cannabis Control Board in correspondence from David Scher dated February 16th, 2022 and February 23rd, 2022.
Which will be ratifying the testimony that we took when we didn't have a quorum 2 weeks ago. It has been moved that the rule be approved. Is there any discussion? If not, all those in favor say aye.
Aye.
All those opposed say nay.
Nay.
And the rule passes. One vote in dissension. 5 present.
Got a quorum and
Which brings us to 21P39. The circumstances around this rule, which is the second of the 5 rules to be presented to us about cannabis, is the same situation as the first rule we just approved, except there were some people who sought to testify, and in this day of communications, they didn't get their question on time. True, and no fault or blame, and which means that they are not eligible to testify in person unless the committee votes a majority to say you're welcome to testify. So before we act on this, there has been a request to testify by
Catherine Dantley, representing really the Vermont Medical Society policy, plus we sent a letter with a number of doctors signed on.
So what's the committee's pleasure on allowing the witness seeking to
I
join us.
move that we allow the witness to speak today.
Hearing no objection, you are welcome, and we're ready to hear some testimony. Take a seat where you are comfortable. We have,
Actually, you can move.
a table the size of which we've never had before, and we are totally in new territory. As when you are ready, you will identify yourself for the record.
My name is Dr. Catherine Antley. I'm a community physician in South Burlington, and I'm here representing really the policy that was passed by the Vermont Medical Society in November. And I understand that that was just a few hours or days after the committee had issued some recommendations. And therefore, they did not know of our recommendations when they looked at theirs. The Vermont Medical Society spent enormous amount of time researching this issue, and we are we have a view towards the law which was passed to implement this act safely. So in order to enact this safely, and we feel like that's the intent, there are a couple things that we feel sure would need to happen. The public must be informed of the risks. The risk, as we know it scientifically, what the consensus is, what the settled science is. Recently, Colorado has passed warnings on their cannabis, and this happened in, I believe, December. And you have a copy of these warnings, and this paper that I just passed out, and they include risks and precautions warning. Use of marijuana concentrate may lead to psychotic symptoms or psychotic disorder, delusions, hallucinations, or difficulty distinguishing reality. Number 2, mental health symptoms and problems. Number 3, cannabis hyperemesis syndrome. Number 4, cannabis use disorder, which means dependence, including physical and psychological dependence. Those are listed on the Medical Society's warnings. The Medical Society feels strongly that Vermonters want to be informed decision makers. We were first in the nation to pass the GMO labeling, and accurate labeling is important for Vermonters to make informed decisions about their health. Furthermore, as physicians, when someone presents with one of these diseases, and I can go into some detail about the different diseases that occur from the use of concentrated marijuana, THC. But one of them, for example, is cannabis hyperemesis syndrome. This is uncontrolled vomiting. So the person is vomiting, they can't even keep a drop of water down. It's extremely painful. They also call it scromiting, which means screaming and vomiting. When they come into the ER, and our ERs are actually inundated with these presentations. And it's expensive because when you have someone who presents, you don't know if, for example, it's gallbladder or it's pancreatitis. So you end up, especially initially when you see the patients, you'll do a CT scan and you'll do various, it takes a while. There have been unnecessary surgeries. And there's a group of pro-marijuana, pro-cannabis individuals who want, safe marijuana. They've been afflicted with this, and they have started a campaign to tell everyone, let people know this is happening. We're suffering. We've had surgery that we didn't need. We're now on opiates for the pain that we wouldn't have been on otherwise. So the reason that this warning is so important is because when a physician confronts the patient and we say, for example, Mrs. Jones, you've been in here 5 times in the last week, and we think it's related to your high use of marijuana, they deny it. And it's and the treatment is to stop use. So if the treatment is to stop use, we can't have a correct standard of care for these patients. We can't treat them to the highest and best standard of use that we should be doing, because they won't accept that this is their problem, that this is the diagnosis. We see this especially, so this cannabis psychosis syndrome is very clear. We also see it with the other, with psychosis especially. Someone hears voices, they don't know if they get paranoid, they don't know if you're their friend. It's even harder. If these warnings were clearly on the label, if this committee approved these, then the person, when they buy it, they'd know that. When these things came up, they might think twice. And if they could, they would stop. Mom would know it. Wife, husband would know it. The whole community would know it. Your boss would understand. Oh, that's what's going on with this person. The treatment is to stop. So that's one of the most important things. We feel very strongly that these warnings need to be on there. They have been passed in Colorado. The Colorado Psychiatric Society has done a deep dive into this, has researched. I have sent around a copy of Dr. Libby Stout has done a compilation of the literature, but really with a group of psychiatrists and the Psychiatric Society in Colorado. And our Vermont Society has as well. So that the other thing that if you look at the two side by side, so this is the cannabis, I don't think it's on there, I'm sorry, I can give one to you, but if you look at it side by side, this is the recommendation of the Cannabis Control Board over here on the, if you look at it, that's the Cannabis Control Board. I'm sorry, I have to give it to you afterwards. I'm gonna have this copy. And then this one, ours is clear, you can see it from far away. It's not got a lot of different words on it. And it's got psychosis, impaired driving, addiction, suicide attempt, uncontrolled vomiting, harm to fetus and nurse. So some of those things are on this, but one thing that we particularly, but some of these aren't. So the CCB's warning that they've come up with does not include psychosis. I'm here because we feel strongly that psychosis should be on this label. We feel strongly that addiction, suicide attempt, uncontrolled vomiting, and the other should be on there as well. And we also have a star, which we got from Colorado, this caveat. This can occur in individuals with no previous history of psychosis and mental illness. So I want to talk a minute about why Colorado, after 12 years of, or 10 years of a commercial cannabis situation, took this back to the legislature and did this. There are a lot of reasons. One is their constituents were calling them because their friends, neighbors, loved ones were becoming psychotic and not getting better. Number two, their own families were in fact impacted. In the legislature in Colorado, the representatives and senators, families, they have, in other words, people are seriously ill and they won't get better. And these folks would be well, but for their cannabis use. When the legislature understood that, when they met with the doctors and they understood what was happening and what the research shows now at this point in time, 2022, and then they heard testimony for like 9 hours in the Senate and the House. This bill passed that required these labelings and required them to look at the THC limits almost unanimously. Now, this is a group of people who were majority were passed. In 2012 they passed the legislation without any question. They've all come to understand that this is a public health risk. And when Bob Troyer came, who's the attorney for Colorado, U.S. Attorney for Colorado, appointed by Obama, and he oversaw when marijuana was legalized in Colorado. He came and testified to the GovOps committee remotely. And one of the things he said is, you will be tasked, the legislature, when you do this, you will be tasked with dealing with with issues that the EPA usually deals with, environmental issues. You will be tasked with dealing with issues that the FDA generally deals with. And this is the type of thing that the FDA would come out and say, these are the risks. You know, we need to let you know that these are the indications, whatever. So this, so what has happened in Colorado is they've gone ahead and done a lot of research. They've come to these conclusions. They've passed this really groundbreaking law. They're in the process. This is already law, but they're still working on other parts of it. One is a scoping review of all the literature. I think they have 50,000 articles of the harms of marijuana that they're, you know, assessing which ones are good. I mean, it's a major process, but it's a huge state, right? They have a lot of resources. So I really think, we really think that Vermont is a science-based, you know, we like to do science-based policy. We're interested in looking after the least among us. I think it's really important that our law, the rules protect and inform Vermonters accurately. I think, you know, I think that's, I have some other handouts. The Colorado Psychiatric Society did a white paper, and they came to the same, you know, conclusions, and I think that's important. And a lot of this literature has come out of Europe, and there are, it's not just one, but a number of researchers who are looking at that, and they have come to the conclusion that psychosis, marijuana, cannabis-induced psychosis, which is a diagnosis, is higher in locations where the concentration of THC is higher. I think that's an important statement for everyone to understand. Incidence of psychosis and schizophrenia, basically the worst of all marijuana, all mental illnesses, which is, you know, destroying, life-destroying, very difficult to deal with and very expensive for a state, is higher, you know, the prevalence is greater in places that have higher use of high potency cannabis THC.
So
Yep.
I'm gonna interrupt you and then turn it back to you. The testimony you are giving is customarily presented to the committees of jurisdiction. And you would be speaking to the healthcare committee prior to passage of a bill. We're looking at the rules to carry that bill out, and the reasons for not approving the rules would be that it's contrary to legislative intent, or it fails to carry out what the legislature called for. How did administration or those folks who have written the rules write them? They have to make decisions on various parts. And if someone were to make a motion, or the committee were to vote by a majority not to approve the rules, we would be obliged to say what failed in the legislative rules process.
Happy to do that.
Sometimes we note that witnesses came in and were concerned that the rules failed to do something, and we send a letter to the committee of jurisdiction and say, hey, you probably should have done this when you wrote the rules, and the committee of jurisdiction will make a decision on whether to make a recommendation or not.
Who's the committee of jurisdiction? The health committee.
In this case,
It's a number of committees, the health committees, the judiciary committees, the option of the committee of jurisdiction.
it went through several committees because, as you see, it's a 5-part series. Some deal with you know, laws and penalties, and others deal with health issues. So this committee makes no amendments to rules. Sometimes we say we're not going to vote on the rule, and we'll give someone else a chance who has the authority to do that. That's not us, we're up or down. And I'm gonna stop there. And I think sooner or later, we're gonna ask you to give us the grounds on whether or not you think we should disapprove of the rule, or, but we're gonna, we're
Yes,
up or down.
yes. There's-
And it's first time here?
Yeah,
Okay, and you come at the last minute, so the floor is yours. But remember that we have a narrow view, so thank you. Go.
we're happy to do that. And I think, I mean, I don't think I know. We do not think that this fulfills the law, the act, the intent of the act. No, it does not. I'll give you another example. This says this may be habit forming. The Vermont Medical Society and the Colorado law warning says it develops use disorder or dependence. We have addiction. We don't use the word, we use use disorder, but addiction is also still used. We don't use other deviations of that. But in terms of what lay people understand, habit forming, walking my dog is habit forming. Working in the garden is habit forming. They're good things that are habit forming. Brushing your teeth is habit forming. It does not connote the pain and the suffering that this person may encounter when they see the word addiction for them and their family. So that's just another example. The suicide attempt, the Colorado Child and Adolescent Psychiatric Society came up with their warning may cause suicide attempt or self-injurious behavior. We have not just one article, we have numerous articles on this now. In Colorado, the #1 substance found in completed teen suicide is now THC, and it used to be alcohol. And there's also evidence that it does lead to depression. Basically, the molecule attaches very closely to the receptor and won't let go. And then you get used to this very high. And so then when it does go away, you don't have your natural anandamide. And that's sort of the basis of why it does.
Senator Squirrel had a question.
Sure.
Yeah, I mean, I appreciate what you're coming in and speaking to. We still can't change the rule, and I think this is a conversation better for the committee's jurisdiction. But I have a question for alleged counsel. Did we get letters from committee chairs regarding these two rules?
I believe you got a letter in response from the chair of House Government Operations. I don't know if anyone other has come in.
And they said what?
They said that it did meet
Did meet
legislative
the
intent.
intent.
And then Michelle is here and we were just emailing because we're in a virtual world. And I think there's something key in the law as it was passed that bears on this conversation when it comes to legislative intent. And I'm hoping that that's what Michelle is here to talk about. If the committee.
Good morning, committee.
Good morning. You've been listening in to the testimony?
I have, and I did just want to share with you, I did speak to Senator Sears after your last meeting about.
Please identify yourself for the record.
Michelle Childs, Office of Legislative Counsel, and I work on the cannabis legislation. And so I did speak with Senator Sears after your last meeting, and he did indicate to me that he was fine with the rules. I think he had intended to fill out the form, and I can circle back with him to just make sure that he lets you guys know that he didn't have any concerns. And then the other piece was, I think that Anthea was alluding to, is the statute does require the board to be working with the Department of Health and development of the warning labels. And so maybe Mr. Scher can talk about the board's experience in working with Department of Health on what they're doing.
I have written to myself that Mr. Scher will be next. And you've asked several questions. I think we're going to ask Mr. Scher to respond to a couple of what you've already presented to us, and then we'll go from there. Mr. Scher.
Thank you, Mr. Chair. The board takes these issues around health and safety extremely seriously. The legislation required the board to formulate its warnings in consultation with the Department of Health. The board did formulate these warnings both in consultation with the Department of Health and with the explicit approval of the Department of Health. The process was a robust process. Commissioner Levine personally sat on the committee the subcommittee, I should say, that helped formulate this rule. And Commissioner Levine and staff at the department did review the warnings and did again approve the warnings. And the board felt that the most responsible way both to honor the legislative intent, which about consultation with the department, as well as to ensure public safety, was to be very deferential to the Department of Health in the formulation of these warnings. And for that reason, the board has not attempted to edit or override or do anything other than what was approved by the Department of Health. So I do believe the board very much was within the legislative intent and the legislative directive, explicit directive, to consult with the department and did its best to honor public safety by, in fact, consulting and operating under the explicit approval of the department in the formulation of these warnings.
The witness will remember, we vote that either they met their obligation as the rule writers or they haven't, and we have to have a specific reason. And we don't get into policy. Question, Senator Benning.
David, I noticed in the packet that we had received, there was a letter from Jim Dumont. And if I understand his letter correctly, it's along the lines of what Dr. Acne is now presenting to us. Was that letter considered in the conversation leading into the rules development?
Yes, it was. All the input from, the Vermont Medical Society and Jim Dumont, who I think was working on behalf of at least some folks who are also involved in the Vermont Medical Society, although people can correct me if I'm wrong there. That information was considered by the board and by the advisory committee that included representatives from the Department of Health in coming to the ultimate conclusion about what the health warning should look like.
Okay, thank you.
I think there is some confusion, and I think it would be helpful to hear from the commissioner. We have been in contact with the commissioner directly, and he has written us that he and the board and the health department are fully aligned with the warnings issued by the Vermont Medical Society. I think what's happened is that we're in the middle of a pandemic, and our commissioner is very much overtaxed. And I think it would be helpful to look at that. When you look at the committee that was being referred to, the commissioner is on it, and then we have a select board member, and then I believe a police person. We believe that the law states, in fact, the law does state at some point that the CCB chair shall evaluate whether adding CBD to THC will make the risk of psychosis less. It is our view that in addition to some of these other things, that was not evaluated rigorously or robustly. They cited when they looked up their letter that they looked up about psychosis, they referenced an article from 2006 by a leading physician named Wayne Hall, who then said we might have something with psychosis and cannabis. And he then wrote another art. Time went on, and the evidence has grown. Every year it grows. And at this point, he wrote an article which said, absolutely, cannabis is a component cause, can be a component cause of psychosis. So we don't feel like that was a robust investigation into the question. Like they didn't fulfill what they were tasked to do by the
Representative Squirrel.
Yeah, again, I think this is information for the committee's jurisdiction. It would be my suggestion to this committee that we make a decision about the rule itself, up or down. And I would also, after that, make a motion that we write a letter to the committee's jurisdiction relaying your concerns and give them the option and you the option of going to those committees and presenting your case.
How would the ruling be changed? How would that process result in change?
This committee is not authorized to change anything in what we have before us. It's authorized to make suggestions that the committees of jurisdiction look at things further, to take more testimony if they feel it's appropriate, and to make recommendations to the legislature to change the law to see that things they recommend become put into statute. We are simply looking at the rules we have before us and whether or not the folks that have written the rules have done their best to follow the law, and we stay away from the individual policy aspects of it. So I perhaps should have asked our attorney to say what I just said in legal words.
You did a really good job. I would have read from the rule and probably bored everyone, but there are just limited grounds on which LCAR can object, and even if LCAR objects, LCAR cannot change anything in the rule. It would need to go through the rulemaking process again.
Should we object, the rule will take place regardless of our objection. But were we to object and someone went to court to say the rule wasn't lawful, our objection would give that person a better advantage in court than if we had approved it, in which case that person who would go to court to object would have a much tougher time because they'd have to provide more proof. So our choice is up or down. And Senator Representative
Another way to put it is what we think on the policy levels are relevant.
Yeah, it's whether or not they've gone through the process, heard from the people they should hear from, written rules that cover the topics that they've been directed to cover, not the nitty-gritty of science and whatever. Representative Higley, you had
Mr. Chair, if I could, I know we're pressed for time, but again, I think this is very important. I do have a question for Mr. Scheer, if I could. Mr. Scheer, I'm looking at, the comments section, and it talks about the potency for cannabis should be limited to 15%. I know the legislature, as well as the Cannabis Board, received, I believe it was in November, a resolution from the Vermont Medical Society. Is that where that request came from? And I noticed underwards, the response to that, of course, is the board has already decided not to adopt a recommendation. But my question is, did that information come from the Vermont Medical Society and others? And who would the others be that suggested only a 15% max on the THC?
Representative, the folks who I recall making that specific recommendation were primarily the Vermont Medical Society. It is possible that there was another commenter or two who adopted that as well, but I think the primary proponent of that was the Vermont Medical Society.
Thank you. And just one other final comment. I know it seems like a lot of this information is actually relatively new, even since November, in regards to maybe what other states, Colorado and so on, is doing. So I think it is a good process to get it back in before the committees. And like I said, we're taking up information on a current bill and Bill Ops currently with a lot of these situations. Mr. Silberman has been in testifying in front of our committee as well. So hopefully we can work some of these things out in committee as well. Thank you.
Thank you. Senator Benning.
I'll just kick in. Dr. Ankney and I are quite familiar with each other because when the first proposal was made to legalize a small amount, I believe we met years ago when I was in government operations and we took hundreds of hours of testimony. Subsequently, Dr. Ankney was also in judiciary. We've had many presentations around the state. I admire her passion. She is very committed. Would have certainly preferred that we not go down this path to begin with. But I don't want to leave anyone with the impression that she is new to the process. She is very familiar with the process. And I share one concern with her. I do hope that in the end, we are retailing this product in a safe way that covers all the bases possible. So I applaud the continuing observation of what is registered as a concern for anyone. When I had read Jim Dumont's letter, it made a lot of sense to me that if the current packaging requirements have language that are 138 words, and this proposal goes down to, I believe, 38 words, any packaging of this material, it can't have a package that's 6 miles long in comparison to what's microscopic in the package itself, because it then overwhelms the packaging with the language of the wording itself, and nobody reads a lot of words. People do read a short amount of words. If these are legitimate concerns, I think that they do have to be within the committee of jurisdiction. This is an ongoing process. It is not perfect by any stretch, but I have to give credit to the board for taking all of the previous research, doing the best it can under the circumstances, and in getting this project underway, has done everything it possibly can. Now, if Colorado has taken a second look and has decided that packaging needed to be adjusted, that is a normal course of events for how this is all going to work. And I don't have any hesitancy in saying, I suspect Dr. Ankney will eventually come across something else that may be a major concern and ought to be brought to the committees of jurisdiction. But I do hope you understand this committee has a limited capability in what it does. It either has to vote the rule up or down, and we have to take wisdom from the committees of jurisdiction as to whether or not what we did or didn't do is going to be changed down the road. But it is those committees of jurisdiction who have the capacity to delve into all of these issues, not this committee.
So I think I'll just finish by saying if your son or daughter or husband or wife uses marijuana, looking at the label that you currently have in front of you, and then develops psychosis or schizophrenia, which is an increased risk we know, or develops a use disorder, which you then have to pay for, I think you would want this committee to vote this down.
Thank you. We're not going to vote it up or down without a motion. And we have a committee to come in and speak your piece. And I wouldn't disagree with Senator Benning's characterization of your hard work and intents here. But the next three items, I think we're going to be brief, so we've taken more time than we had expected. What's the committee's pleasure? Representative Squirrel.
I move that we approve the rule, which is 21P39, with the modification proposed by the Cannabis Control Board in correspondence from David Shear, dated February 23, 2022, and March 8, 2022.
So technically, to approve the rule and make some corrections that had been presented to us a couple of weeks ago that were not controversial. So the question is, shall the rule be approved? Is there any further discussion? If not, all those in favor say aye.
Aye.
All those opposed say nay.
Nay.
So the rules have passed. Representative Squirrel, do you want to make your
Yeah.
motion before we move on to the next?
Yeah, I'd like to make a motion that we send a letter to the committee's jurisdiction relaying the concerns of the Vermont Medical Society. And I guess our ledge council can capture the conversation and any issues.
We'll have it very.
And that rule will come to, that letter will come to us the next time we meet, and then we will approve, you usually approve them because they are so well written and inclusive and forward to the committee's jurisdiction. Senator Bay.
Mr. Chair, I don't know whether representatives consider this to be a friendly amendment, but I would like to be able to have the committees of jurisdiction, all of them, examine the Colorado situation, because if Colorado changed its statutes to accommodate these concerns, our committees of jurisdiction should be beyond the healthcare committees. It should be in government operations and judiciary. So I'm just hoping that language will rope those additional committees into conversation.
So Representative Squirrel is a friendly amendment to the motion and has been noted by our attorney.
Healthcare committee.
Yeah.
I think the healthcare committee was where the original target was. I just want to make sure they.
Not the letters. Our letter will go to the several committees. Is there any, hearing no objection, the letter will be drafted for us here at our next meeting, and we're going to move on to the next item on the agenda. Thank you very much.
Yeah.
Thank you to the committee.
Excuse me?
Just thanking the committee. Thank you, Mr. Chair.
Okay, that's what we're here for. Okay. The next three items, P41, P42, and P43, all have in common that they are rules that are already in place and are before us because the time is running out, and that they contain no changes to the emergency rule that is currently in place. And our council will correct me if I have misrepresented any of that. So this is, we have three rules, one after another, that are being sought to be maintained as emergency rules, and with no policy changes from the existing emergency rule. So the first one is P21. 121 P41, and Heidi Moreau from Policy Analyst of the Department for Children and Families. Who is she here?
I'm here.
Yes. And you will verify my comments or amend my comments as would be appropriate.
Yes, good morning. I'm Heidi Moreau, Policy Advisor for the Department for Children and Families. Your comments were 100% correct. The three sets of final proposed rules are identical to the emergency rules that were filed back in October. The department didn't receive any comments on the non-discrimination provisions. There were some comments on other provisions of the center-based childcare and preschool program rules and the family childcare home rules. And some of those issues the department will take up in future rulemaking, and some change at all. But all of that's detailed in the letter to the committee. There is one typo in section 6.1.5.1.4 of the family childcare home regulations that Representative Wood caught yesterday evening in her review of the rules that the department would like to correct as part of this rule filing. The word licensed should be inserted before FCCP. That's on page 72 of the family childcare home rules.
There's your
Typographic error, they can fix the view.
we if there's no objection, we will correct that typographical error when we make our considerations. Would the witness be giving us the same testimony on all three of the rules before us?
Yes.
Welcome, Representative Odie. I apologize for not recognizing your arrival just after we had begun our meeting a long time ago.
I would just say, can we make a motion to have all three of those approved so that we can?
As a package?
Yes, please.
Hearing no objection, someone to move all three of them together. We would proceed to vote on all three of them together.
Thank you.
What's the committee's pleasure?
I agree with Carol.
Senator Benning has moved that we approve the three emergency rules as a package. Is there any further discussion? If not, all those in favor say aye.
Aye.
All those say nay. And all three of the rules have been approved to be continued as set forth. Which brings us to the Department of Public Safety Vermont Electricians Licensing Board. And the patients of the day, person of the day goes to John Black, Chair of the Department of Public Safety. Mr. Black, the floor is yours.
Okay, I can briefly outline the rule package. It is very similar to the package of 3 years ago. As you know, every 3 years, the NFPA produces a new book, NFPA 70, which is the National Electric Code rules. This year, we have minor changes to the GFCI rules 210.8. Specifically, the new rules modify the language a little bit so that we can better regulate the 240 volt outlets that are now required to be GFCI protected. And the reason for this is manufacturers still are not up to speed on false tripping of these 2-pole breakers. And that's just to give a little added time. Just to let you know, the 2023 of National Electric Code will be out shortly. So this rule package will be in force for about a year before we start this all over again. I'm open to any questions.
Questions for the witness? Representative Squirrel.
Yeah, I have a question. In the submission, it indicates that substantial arguments and considerations were raised for or against the original proposal. Then in part 13, you said the agency has included a letter explaining in detail the reasons for the agency's decision to reject or adopt them. I guess I can't find that letter.
Bob, can you help me with that? I'm unaware of the letter you're speaking of.
Good morning, everybody. Bob Sponable, Deputy Director, Division of Fire Safety. I, with John's assistance, submitted the request, and this was be honest, my first time doing all of this, so it was a little bit daunting for me. Whether or not something is substantial or not, I guess is what the question was, and I thought that meant any changes whatsoever. After further discussion, I think that's one of those boxes that I didn't go back and change. That the changes that we made were not substantial or significant, and had very minimal impact at all on the entire rule package. So that I apologize for. So that's why there's no explanation for that.
Okay. All right.
I think it might actually be in your packet.
I'm sorry.
I think it might be in your packet. I think there's a letter dated February 17th, 2020.
It wasn't in my packet.
Okay. If
That's fine. I'm okay with the answer. Thank you.
And with Mr. Black, did you say you were almost back to starting over again on the next revision?
That's correct. NFPA produces a new book every 3 years, and 2023 is the next code cycle. We're currently on the 2017 code.
What's the committee's pleasure?
So moved.
Senator Benning has moved that we approve the rule as presented.
Rule 21P40.
Is there any further discussion? If not, all those in favor say aye.
Aye.
All opposed say nay. Thank you, gentlemen.
Thank you.
We have finished our agenda items for the day. Charlene has recommended that we not meet on the 17th, a week from today. Have you had anything that has come to you since that recommendation that would change it?
There's 3 rules that came in yesterday and the day before. 2 of the rules are cannabis, 3 and 4, and 1 is vital records. I don't have on my the dates for scheduling of meetings the 24th, but instead of meeting the 17th, we could meet the 24th and have those 4 rules on.
I see nods.
Yep.
Several of the committees of jurisdiction will be coming up on their crossovers on the 18th, so.
Crazy on the appropriations.
If you use the word crazy describing the legislature, people might actually take it as an accurate comment.
Well, Mr. Chair, in the words of former Rep. Linda Myers, can we adjourn now?
Senator Benning has moved it to we adjourn, and if the question, if so, all in favor say aye.
Aye.